Bird versus Bird, Caps versus Caps, in case there's anyone here. Crawford versus Crawford. Russell versus Curtis. Donaldson versus Donaldson. Fox versus Fox. Graves versus Graves. Turner versus Gutton. Hammer versus Hammer. Hassett versus Hassett. Am I saying that right yet after all these years? Taylor versus Houchins. Hudson versus Hudson. Jimenez versus Jimenez. Dye versus Jones. Muse versus Muse. Pennington versus Pennington. Rich versus Rich. And Smith versus Smith.
Continue to
All
July
those are
16th.
continued. Okay. Electronically submit the orders. Thank y'all very much. Civil docket. Melissa Dugan versus May Amos.
Judge, that's my motion for you to approve the plat that we submitted that was in conformity with the order that was entered.
Well, and in your motion, it had, I'll approve the plat, of course, but it had a motion to compel the execution of a deed. Is that the same one?
Yeah.
Are you, how long, if they do not comply with that, are you gonna move for a commissioner's deed or what are you gonna do?
Yes, we will.
Okay,
And then we still have damages to present. But
okay,
we needed to get the plat approved before.
okay. Well, I'll go ahead and submit the order on the plat that's been laying out there for a long time.
Oh, thank you.
Okay, thank you. Clary versus Clary. Okay, what we got here?
Well, Judge, this was my motion, and I think Mr. Carter has filed a response. My client's visits were suspended with the children back several years ago. And she's just wanting to reestablish a relationship with the children.
How old are the children now?
The oldest
16
is-
and 11.
yeah, go ahead.
16 and 11. Sorry, I spoke over.
That's okay. Again, my client, I mean, she's not asking for anything specific. She's not asking for anything outrageous. She's just wanting the opportunity to reestablish a relationship with them.
What's your client have said?
Your Honor, given the time frame and the nature of how that ended, he would like to go either through a therapeutic route, like a counselor, meet with the parties and help advise on how to move forward, or at least have a friend of the court or guardian ad litem talk to the children. He doesn't feel comfortable jumping straight into visits, again, given the amount of time it's been.
And Judge, I think that I feel like a GAL or a friend of the court is likely to also recommend some sort of therapeutic setting. So I think in the interest of this happening for her sooner rather than later, it might behoove us to bypass
What do you
that.
suggest as far as,
Me or him?
I'm not talking to him because you'll be amenable to probably going the normal route of some sort, but do you have anything in mind that your client would be agreeing with?
I do.
Judge, before I've had cases where a therapist talked with both sides and when they thought they were ready, kind of brought them into a
Do
meeting.
you have
together.
anybody in mind?
I don't. I've not done this in a long
I
time.
do.
Yeah,
I do. There's a program through Western Kentucky University that has been very successful. It's a trauma-based program. So it treats the parent and the child. They are treated individually and then they're brought together. And it's a specific program that
what's
is,
the name of the program?
it's it's Collaborative Regional Evidence-Based Trauma Treatment. They have a location in Glasgow that they're there once a week and they're also in Bowling Green. There's no
What's
cost.
the credential of the people?
So all three of the therapists there, well, they previously worked at the Advocacy Center in Warren County for years and years. They're all licensed clinical social workers. They all have the specialized trauma treatment training and certification.
There costs involved?
There is no cost involved to the family. This is all through a grant through Western Kentucky University. And then the way they approach this is very holistic. They understand that the goal is to reestablish a connection between the parent and the child. And they set a specific.
How long does it take to get in?
Right now, I think there's a waiting list, but it's not very long because it's a specific program. It lasts about 8 weeks. It cycles through fairly quickly. So I know that I just had this morning and.
Well, I'm
Metcalfe County
amenable
was-
to trying something. I've never heard of this program before, but it seems, well intended. How do you feel about that?
Judge, it sounds appropriate to me.
Okay, well, let's do an agreed order on that. And I guess the parents go over and get interviewed
So it's
first.
an online referral. I think my client would do her intake information. Mr. Cleary would need to do the intake information for the children and give consent for the program. And then they would be contacted to get it set up and come in.
That sounds good. Why don't we do that? Let's just do an agreed order to try that, see where it goes, and both of you can see how you feel about it when you get going, try to be open-minded about it, but we'll try that, okay? I hope it works out for everybody because as we all know, it's important, no matter what traumatic situations have happened in children's lives, that they feel that they haven't been abandoned and that there is hope for renewal and redemption and people can change. Because God knows in the world they're going to grow up in, they're going to face those kind of challenges. Okay, well, thank y'all very much.
Thank you, Judge.
Okay, Dyer versus Matthews. I'll start bringing charts out on me this time of day here.
We may not need them, Your Honor.
Okay.
Henry Pell and I represent Charles Dyer along with Ms. Brown.
Okay, what we got here?
We got a motion for summary judgment to establish title to superiority of a deed of title.
I read that last time. Where is the other side here? I've really never, and I could say I was an old real estate lawyer because I'm an old any kind of lawyer now, but for years, my dad was county clerk and I grew up in the county clerk's office and I knew how to do title searches back then and did a lot of oil and gas work, but I don't know whether I've ever seen a contested deed contest where someone didn't come in and try to do an adversity claim or something, and doesn't appear to be pleadings along those lines. Is that correct?
That's correct. He replied to the filing and then filed nothing since.
Yeah. And this was the piece of property I read that part of it was in that portion of Monroe County that was part of Cumberland County at the time, was it, when this happened?
Yeah, so kind of brings up.
Yeah.
As you can see, there's Mr. Dyer's main property is over here in Cumberland County.
Yeah.
That little piece up there in the upper.
Where is Turkey Neck being there? Is this down near the
This is Marrowbone Creek up here and this is Leatherwood Creek.
Leatherwood? Yeah, it goes back. I know where it joins in back to Leatherwood.
But this little Pentagon piece up here is what is in dispute.
Yeah. And is it just rough land?
This is rough land.
Even rough land's worth a lot of money now. A lot of people like to move the end of the road.
You could be just one block past the end of the road if you were
Yeah,
there.
I understand.
Second one shows the action.
Well, the only valuable piece of land they ever took is when they came across the river and got that portion of Cumberland County that was in the bottom down there. I don't know.
But anyways, this
I
property
I read it.
okay.
I read it. I understood. So just submit a judgment.
We have e-filed a judgment, Your Honor, and we have a physical copy here if you'd like.
No, it's e-filing is fine. Okay, well, thank you very much.
Thank you, Your Honor.
Yeah. Okay. 5-4 Lean LLC versus. Okay, what do we have here?
Judge, the parties have been able to reach an agreement in this case, actually. We were here on a time sharing issue. I know.
Sorry to take your job away from you.
Yeah, I mean. Okay, well, you were cited, let's see if everybody still agrees, okay?
Absolutely. The mother shall receive time sharing on Mondays and Tuesdays. The father will receive time sharing on Wednesdays and Thursdays. They will rotate weekends. We will have no restrictions for Miss Scott's mother and sister as far as visitation goes. The minor child will attend Tompkinsville Elementary School, and this will begin on May 29th.
How old is the child?
Three.
Well, everybody's in accord, is that what you agree?
Yeah, I think the only thing I would clarify is I think what he's agreeing to is that the child will attend Tompkinsville Elementary for the 2 remaining years that she has a child that's at that school, and then they might revisit the issue
She
at
said
that,
it's 3
at
years.
that point.
3 more years, she'll be in
So-
3rd grade.
Or 3 more.
3 more, yeah,
Yeah,
yeah. So,
okay,
and I think they both have agreed that for him to be screened for possibly starting preschool this fall.
that'll be fine. Y'all submit the order. Thank y'all.
Thank you,
Good luck-
Judge.
Good luck to both of them. Middle Tennessee Natural Gas Utility versus Sheffield. Hello. Well, I have read your Public Service Commission statement. It was absolutely no help whatsoever. It was well written, but then I looked at the federal aspects of it. I really don't understand why somebody didn't bring this in federal court or take it to federal court. But I've got it here, and I don't guess anybody's going to remove it to federal court. I need a little proof on how long that pipeline has been there, who owned the property. Y'all could probably agree with that. On that, we could probably, somebody could make a statement. Right now, we would avoid taking, how long has the pipeline been there?
1990s.
Okay, and who owned the property then?
Holland,
So your client didn't own it?
he bought it 3 or 4 years. He bought it in the 90s.
Yeah. And it's been there ever since. And is there any document that shows it was by permission or anything, or? Well, it would appear to me, and I don't know whether it's been pled this way or not, it would appear to me that we'll ultimately get back to see whether it's an easement or not there. And it would appear, unless there's, I think you could presume there's an easement because it's been there all this time and it hadn't been challenged. And there's no evidence that I've seen in the record that there was any claim that it was there by permission. So I would assume that if they have an easement, as a matter of law, they have an easement, then they would have a right to access the easement to make it safe to the public and continue the use for what it's there. The problem that I have is if I enter a judgment in toto for them, what protection does the landowner have that these people that manage this organization now might have every intent to go in and compensate them for loss when they go, if they have to go back in again or keep it up in sort of way. What guarantee can I give to make sure?
You can say in your order that they are required to restore the property as it is now. In fact, what they're asking the court to do is let them go in there and maintain the status quo, maintain a functioning pipeline through that property.
No, but does he plant over the top of the pipeline now? It run, how far across him does it run?
1,700 feet.
Yeah. Is that in a field that is cultivated?
Part of
deep
it's
is the pipeline?
cultivated, part of it's a hay crop, part of it's pasture ground. That's my understanding.
But I think that the property that's in question here is along a river bank or a creek bank.
It is, but it is, so when it gets up off the riverbank, how far across him does it go? Is it going somebody else pretty quick? Got it plat?
Well, we do have a plat, but in our affidavits, we were asking for approximately 500 feet usage to replace that pipe.
Well, I'm gonna allow you to have the 500 feet to do that, but I'm gonna leave it open for your client to come back in to talk about damages that he received, that sort of thing, and I'll make a separate ruling on that. And then it would appear to me, you're not asking for a judgment validating the easement, are you? You're
Not
just
today.
trying to get access to
Not
it.
today. Now, that is in our complaint to a declaratory judgment recognizing
Yeah,
this easement,
But
but not today, just.
do you have any
just when it's-
defense to the declaratory judgment
Yes.
as far as the easement?
Yes, because we allege that it has always been by permission. Every other time they've tried to come in and fix it, they ask permission to come in and fix it. They've never entered the property as a matter of right.
Of course, you can ask permission to come in and fix it without having to ask permission for it to be there. Those are two separate questions.
Okay.
So I won't rule on that issue then. I'll leave that issue and take some proof on the permission aspect of it. But I'll go ahead and give you, I will enjoin him from interfering with you going on to the property and fixing it. Okay. But I would say that if there's anything that you can do while you do that, a word to the wise is sufficient. If anything you do would make it less intrusive on his property, it would be good when we deal with this ultimate issue.
I understand.
And you'll need to give him notice, let's say, 72-hour notice before you come on it for any purpose, okay?
I've submitted a proposed order. Do you want me
You seen
to?
it yet?
I've not seen
I
it.
can review that.
Let Mr. Let him see it and, Mr. Stevens will take a look at it. And we'll see if there's anything, we'll enter that, and then we'll address the larger issue. The length of time that it's been there, I guess the issue will be, did predecessors entitled give permission, and is there any kind of tacking thing on that permission, or if it was there a long amount of time before your client owned it, was there intervention or interruption in a period for easement? All those things we can take by proof, okay? Okay, thank y'all very much.
Thank you.
Yeah.